Welcome to the Explainer. If you're an environmental health officer, then you're right on the front line of housing safety. Today, we're digging into Awaab's law. And let me tell you, this is a piece of legislation that doesn't just tweak the rules, it completely changes the game for holding social landlords to account. Right, let's be really clear about this from the start. This law wasn't dreamed up in a committee room. It was born from an absolutely heartbreaking tragedy. Understanding where this came from is fundamental to grasping the urgency and the massive shift in legal responsibility it places on landlords' shoulders. Okay, so here's what we're going to cover. We'll start with the story that made this law necessary. Then we'll get into the nuts and bolts of what it actually requires. We'll look at the super strict new deadlines, how this changes the whole approach to risk, what happens when landlords fail to act, and then we'll zoom out to look at the bigger picture. To really get a feel for the power of this law, we have to go back to the story that forced it into being. This isn't just about policy and paperwork. It's about making sure a tragedy like this can never, ever happen again. Just look at the dates here. For 3 whole years, between 2017 and 2020, Awaab's parents were crying out for help about the mold. By the time the coroner's ruling confirmed the worst in 2022, it was tragically too late. Awaab's law is a direct answer to that awful timeline of inaction. It's designed to make sure no one's complaint goes unheard again. So with that tragic context really front of mind, what exactly is Awaab's law? Let's get into the core principles and what they're actually going to mean for you and your work as an EHO. Okay, the single most important thing to get your head around here is that Awaab's law basically writes new non-negotiable clauses directly into tenancy agreements. This means failing to act isn't just bad practice anymore. It's a stone-cold breach of contract. That gives tenants, and by extension you, a much, much stronger legal footing to stand on. Now, it's important to know this isn't all happening at once. The law's being rolled out in phases. Phase 1, in late 2025, goes straight for the issues from Awaab's case. That's dump, mold, and emergency hazards. After that, it expands over the next 2 years to cover pretty much every other hazard under the existing rating system. Right, let's talk about the bit that's really going to change your day-to-day enforcement rule: the deadlines. These timeframes aren't suggestions, they're absolute. And this is where the law really gets its teeth. So when you're out there making an assessment, the phrases that should be flashing in your mind are imminent and significant risk, and the reasonable landlord's test. That's your benchmark. We're talking about things like exposed wiring, a failed boiler in winter, or a front door that won't lock. Situations where any normal person would expect action, and fast. For these emergencies, the process is incredibly simple and incredibly fast. The second a landlord is made aware of the issue, a clock starts ticking. They have just 24 hours. And that's not just to pop around and have a look, that's to investigate and complete the work to make the place safe. So, 24 hours. That's the headline number. And it's a hard deadline, the absolute legal maximum. In fact, the official guidance makes it clear that landlords are expected to act even faster if the situation calls for it. Okay, so the next category down from emergency is a significant hazard. The key difference here is that while the problem is still urgent, the law allows for a bit more of a structured process. And remember, for phase 1, this category is laser-focused on damp and mold. Now this process, it's a lot more detailed, isn't it? It's not just about a quick patch-up job. It forces a formal investigation, a written report back to the tenant, which is huge for transparency, a deadline to make the property safe, and this is the really clever bit, a requirement to start preventative work to stop the whole thing from happening again. So, first deadline, 10 working days. That's the absolute max a landlord has to get in there and investigate a reported significant hazard like damp and mold. And as soon as that investigation is finished, bang, a new clock starts. 5 working days. That is all the time they have to get the repairs done and kick off that preventative work. These deadlines are tight, and crucially, they are legally binding. Okay, this next part is absolutely critical for anyone who's spent their career working with the Housing Health and Safety Rating System, the HHSRS. Awaab's law brings in a fundamental change in how you think about risk. We're moving from looking at the property to looking at the person. Let's see how that works. Right. This is the key distinction. The HHSRS is property-centric, right? It scores a building's faults based on the risk to a hypothetical vulnerable person who might live there. Awaab's law is person-centric. It forces landlords to think about the actual person living in that home right now and their specific health issues. It doesn't replace HHSRS, but it adds this powerful personal new layer right on top. And this is the real kicker. It means a landlord has to act on information they have, or even should have, about a tenant's vulnerability. So if a tenant says, I have asthma and there's mold in my flat, that landlord is now legally on the hook to treat that report with far greater urgency. That knowledge alone could easily bump a hazard from significant right up to emergency status.
So a law is only as strong as its enforcement, right? What actually happens if a landlord just ignores these new rules and blows past the deadlines?
Now, as an EHO, you are absolutely going to be asked this question by tenants. So it's vital that you can clearly and confidently explain the options this law now gives them. The path for tenants is really clear, and it escalates nicely. They have to start with the landlord's own internal complaints procedure. If that goes nowhere, they can take it to the housing ombudsman. And as a final resort, they have the power to take their landlord to court for that all-important breach of their tenancy agreement.
Okay, so for our final section, let's just zoom out for a second and look at the bigger picture. Just how big is the problem that this law has been designed to fix?
Well, this statistic from the housing ombudsman pretty much says it all, doesn't it? A staggering 50%, half of all their casework, is about damp and mold. One single issue accounts for half of all high-level complaints. And that is exactly why it's the #1 target for Phase 1 of this law. Look, Awaab's law sets a brand new, urgent benchmark for housing safety. The massive question it leaves hanging over the entire sector is this: will landlords just get better at reacting to these deadlines, or will this finally be the catalyst for a proper shift towards proactive property management, stopping these hazards from ever taking hold in the first place? That's the real test.